Okay, I hope you enjoyed lunch. And now we're into our afternoon session of the day on the National Redress Scheme for Child Sexual Abuse. I will quickly introduce our speakers. Again, two presentations in two different parts. One from AidAn McCarthy from Children and Young People with Disability Australia, and from AidAn McCarthy, a lawyer from knowmore. And I believe there's no relation.
Yes.
No. So, yeah. Okay.
Thanks very much, Melissa. I'd just like to acknowledge the traditional owners of the land, the Wurundjeri people, and pay my respects to any elders past, present and emerging, and any who may be here today. It would be good to... So just an overview of the presentation. I'll just talk about our association, a bit of background about the Royal Commission, the National Redress Scheme, including some information from Blue Knot, and our children and young people with disabilities role in the Redress Scheme. And then AidAn will continue with the legal service and describe knowmore and how they fit into the scheme. Children and Young People with Disability Australia is a peak disability organisation that represent people, children and young people from the age of 0 to 25. And we work to ensure that direct experience of children and young people is included into policy and practice. We're a cross-disability organisation with over 5,000 members, and one of our key activities is systemic advocacy. That's our focus. When the Royal Commission for Institutionalised Responses into Child Sexual Abuse was first announced, we became an active participant in that 3-year commission and produced a number of issues papers, one of which I have out the front, and it's enabling and protecting, and you may wish to read that also. I just want to, before I proceed, to say that some information may be distressing. It is very factual information that I'm presenting. However, I wish to acknowledge any survivors who may be in the room, or acknowledge that it can be hard to hear about or read about sexual abuse, and if it brings up any difficult feelings or memories, then you're absolutely not obligated to stay in the room, and there is assistance available to you. Okay, just a few statistics. The Royal Commission went over 2013 to, I think, its final report in 2017. There were 6,875 survivors who made submissions. Of those, and there's a lot of statistics up there that you can see, and of those there were 293 or 80 people with disability, 86% of whom had experienced multiple sexual abuse, 62% said the abuse lasted over 1 year, and 34% said it was pre-1990 in institutional care, and also that 32.4% said the abuse had happened in a school. So what the Commission was hearing, and the Commission did provide individual and private hearings for people, and it's yet to be seen whether the upcoming Disability Royal Commission will be doing that, so it's something that we'll be advocating for. But we would hope that people who are presenting to the Royal Commission, Disability Royal Commission, will have that opportunity to have private sessions. So the barriers to help seeking, and it wouldn't be unfamiliar to yourselves that people with disability express their concern about having their care needs made reduced or impacted. They were isolation and segregation was a barrier, and of course the type of disability and the ability of the person to express what had happened to them was also a barrier to disclosure. There was a lack of trauma-informed workforce in the disability sector, and there were signs were not acknowledged. Signs of abuse were not acknowledged. There were also institutional barriers in relation to the lack of transparent, independent complaints mechanisms and heightened risks for students in schools. This is part of the disability summary of the Royal Commission, which is available online as well. So what is the National Redress Scheme? It's the government's response, or one of the responses to the recommendations of the Royal Commission, and it's to support people who have experienced institutionalised sexual abuse. It acknowledges that many children were sexually abused in institutions. It recognises the suffering that they endured, and it holds institutions accountable for that abuse. It helps people who've experienced institutionalised sexual abuse to gain redress, and that is through either one of three methods. It's either a payment, through a counselling, or through a direct personal response, and that is to hold the institution to have a conversation or an apology or what the person wants to hear from the institution and how they want that personal response to be shaped. The scheme, it's very important to note that, and I know there will be national disability advocacy funded organisations here, and there will also be advocacy agencies who are not NDAP funded. And I think it's really important to note that people with disability may approach you in relation to the National Redress Scheme, and you do need to know that you can only have one application. And so how you assist that person is quite vital because it has an impact on any other decisions that would be made. Interestingly enough, the scheme's run by the Department of Social Services. The easy English version of the document that they put out explaining the scheme did not have that fact in the document. So at CYDA we approached them and we've asked for that to be changed, and it's been an opportunity for the whole document to be reviewed. But I just wanted, that's an example of how we've been interacting with the scheme, because other information for victims and survivors clearly states that fact, but the easy English version did not. So who can apply for the scheme? You have to have experienced institutionalised sexual abuse, and you need to be aged 18 before or turn 18 before the scheme ends in June 2028. So 6 months before the scheme ends, you need to be able to put your application in. Got to check some facts. 12 months. Have to be an Australian citizen or permanent resident, and also applying about an institution that has joined the National Redress Scheme. Some of the technicalities will be explained by AidAn from the legal service. And institutions being held accountable, institutions that were named in the Royal Commission are being tracked to ensure that they do join the National Redress Scheme, because and there's an opportunity on the website of the National Redress Scheme to see institutions who have joined, institutions who are intending to join, and institutions who have yet to make a commitment to join. Just to note that children under 18, if the abuse happened before the scheme started, when the child was young and under the age of 18, they can progress an application, but an outcome won't be made until the child turns 18, as the you have to be 18 years or older to accept an offer. There are a number of agencies in Victoria who are redress support services, and the list, I won't go through all the list because it's too difficult. So there's the address up there that you'll be able to access. And it's important to note that the people who have first point of contact with any person who's a potential participant has received and trauma-informed counselling. That's their practice model. They come from that method of operating. And there's no expectation that a person would sit down and be able to articulate the whole of what they've experienced in one session. So, and what we need to know as advocates, and certainly as children and young people with disability and People with Disability Australia and other disability advocates involved in the scheme, what are the current barriers to accessing the services? So if a person has particular communication needs and they're not addressed and not supported, we need to know. If the website is totally inaccessible to a person with a disability, we need to know. We will advocate for change, and we are doing that on ourselves, but we need to have that information also if you've experienced it. I'd like to talk about also the fact that rural and remote communities have just been responded to for their need to have better access to National Redress Services, and that has been an agency called the Blue Knot Foundation has been allocated to offer that support. And you will note, or you may know already, that Blue Knot is also the national agency that will be supporting people with disability through the Disability Royal Commission as well. So with some good active listening, people will be directed appropriately to supports in relation to the National Redress Scheme, as well as assisted with their Disability Royal Commission application. Just a little bit about Blue Knot. They've got a national helpline. The operational hours are there behind me. There is a national counselling and referral service. That's behind me. There's also training available to advocates, and they offer organisational consultancy as well. So if you have any issues or difficulties, they will speak to yourselves. They can come to conferences and symposiums, but I guess more importantly, they're available to discuss referrals. They also have a range of videos and fact sheets on their website. The new support that was available was just announced in July this year, I think. Was the capacity for Blue Knot to offer telephone or video conferencing support to survivors directly. And I'm not saying it's the best outcome, but it's a better outcome than having no rural involvement. What it does acknowledge is that people can be victims and survivors anywhere, and it's important that there is an active response to supporting the survivors. They also provide support in mentoring any of your staff with capacity building, and to enable you to be able to talk to potential participants in relation to and assist them through the application process. Excellent question. Just checking my notes.
Could you repeat the question?
Yes, is there a charge for the training, is the question. I'm sorry, I don't have the answer to that. I know that Blue Knot have offer a range of training, and recently through Daru there was vicarious trauma training offered, and that was at a cost. So some is at a cost. I would think that if you had a number of staff that required particular training in relation to this work, that could be negotiated. So they do talk about information sharing, mentoring and coaching. So that wouldn't be at a cost. Psychoeducation and increasing the workforce knowledge about complex trauma, and strategies for managing autonomic dysregulation, hypo and hyperarousal, and increasing the competency and competence of working through particular phases of trauma work. It was important for me to bring this information to your attention because Blue Knot, as I said, that it's just a new aspect to the redress scheme, and we want to ensure that as many survivors as possible have the capacity and the ability to tell their stories and hopefully seek redress. The National Redress Scheme is not a... It offers other supports, which AidAn will talk about, including the option to take other legal action. So it is only one response from a legal perspective, but is not at the same level as it doesn't have the same obligations in relation to a civil action if you take a civil action. But AidAn is the lawyer and we'll talk about that. But I would like to let you know that the scheme has taken quite a while to reach what I think is not yet its peak, and that's because the way the applications are being heard through independent decision makers, and there weren't enough independent decision makers on board. So I'd like to say that this is in very little writing. Just an update in relation to the progress of applications. As with many application processes and schemes, if there are multiple institutions involved, for example, that could delay an application for redress. So, and when a person requires ongoing counselling and support in relation to an application that they've made, that can heighten their distress. And so the counselling is available right through the application process and is not part of the counselling outcome at the end of the scheme. So as at the 4th of October, they had received over 5,000 applications. This is the Department of Social Services. They had only made 750 decisions, and of that there are 638 payments. The statistics are there, but I think the most important statistic is in the last 3 months of the scheme, they've processed more applications in the last 3 months of the scheme than they did in the first 1 year of the scheme. So they've made a commitment to employing caseworkers and also more independent decision makers to help survivors through the process, because it's really imperative that survivors get action quickly once their situation or their application has been processed. Our role with the National Redress Scheme is primarily focused on systemic advocacy. It's to ensure that people with a disability, survivors with disability, have equitable access to the scheme, that any other systemic issues that might be occurring can be identified and brought to the operators of the scheme. That's why we would like to hear from you about any issues that you might that might occur in any of your practice in relation to the scheme. We can work with other providers to ensure that some of those access issues are addressed, and the application form is quite an unwieldy, lengthy form, and I think still requires further work for better access for people with disability. we can provide information, assistance and a warm referral to other National Redress Support Services. And it's our absolute aim to ensure that accessibility to all aspects of the scheme occur. Tracking. The contact details for the National Redress Scheme are behind me, and our contact details are also available to you here. I just want to say, in relation to the Disability Royal Commission, our CEO spent quite a considerable amount of time up in Townsville in relation to the education hearings, and something I produced earlier, not me particularly, but we do have a paper towards inclusive education and a necessary process for transformation that we have submitted, and I think it might be of interest. It's available on our website also. And 2 minutes before time. So if you've got any questions, we might leave them to the end of the presentation, if that's okay, so we could address them together, and that AidAn has got time to present on knowmore, which is the legal scheme that was appointed during the Royal Commission and that is now assisting applicants with legal issues through the redress scheme. Thank you.
Yeah. Do you want your paperwork? Hi everyone, my name is AidAn McCarthy. I'm a lawyer in knowmore's Melbourne office. You'll have to forgive me, I've got a bit of a cold, so my voice is a bit going to betray me here. Thank you for having me today, and I want to start by acknowledging the traditional owners of the land on which we're meeting, the Wurundjeri people, and I want to pay my respects to elders past, present and emerging, and to any Aboriginal and Torres Strait Islander people in the room. And I would also like to join with Di in acknowledging any survivors in the room. If it's uncomfortable to hear about that, that's totally understandable, and it's not, a pub chat. Come see me after and I'll give you a card. So knowmore is a program of the National Association of Community Legal Centres, and we're funded sort of alongside the National Redress Scheme to provide legal advice to people engaging with the redress scheme or considering engaging. We were originally set up as, it might be on the next slide, no? Okay. We were originally set up as a legal service to assist people who were engaging with the Royal Commission into institutional responses to child sexual abuse. Now, Di sort of covered a lot of the info about the National Redress Scheme, so I probably won't repeat all of it, so I might sort of fast forward through some of the slides. I'll go into talking about knowmore. So we work with people all across Australia, and we have all our clients are people who experience sexual abuse as children. We have a trauma-informed framework, and we also have a culturally safe practice model as well. So in addition to the lawyers, we have a support services team, and we have an Aboriginal and Torres Strait Islander engagement team as well. There's our team. Oh, and recently we've had some financial counsellors come on board through a grant from the Financial Counselling Foundation, who are able to assist people with their National Redress Scheme payments, sort of at the end of the process as well. So we have over 5,000 clients. Not all the applicants to the National Redress Scheme are our clients, and not all our clients will apply to the National Redress Scheme, but there's expected to be up to 60,000 applicants to the National Redress Scheme in the life of the scheme. So it's running for 10 years. Up to 60,000 people may apply. As Di said before, the National Redress Scheme offers those three components. So the redress payment, which is in an amount up to $150,000. I'll come back to how the amounts work a little bit later. Counselling support, which is either, well, in Victoria, the counselling is offered through services. In South Australia and WA, I believe the counselling is sort of a lump sum payment instead. And of course there's the direct personal response as well, which is like an apology. Now, Di covered the sort of initial points, so the key point I wanted to get to here is that to apply to the National Redress Scheme, a person needs to have experienced sexual abuse as a child in an institutional context. And institution is defined really broadly, and that will be one of the things I focus on, so I'll come back to that in a moment. I wanted to pick up as well what Di said about civil litigation as another option. The redress scheme is to accept an offer of redress at the end of the process. An applicant has to sign an acceptance document that says that they can't bring any further claims against the institution or institutions for the abuse that they experienced. So what that means is that if someone goes through the redress scheme, they have to sign away their rights to bring a civil claim, which is it's the way the scheme's been set up, but that's something that we obviously give people advice about as well. Now, the eligibility issues I wanted to cover were a couple of things. Actually, we'll go back one slide, sorry. The other thing that was on here that I wanted to mention is you need to have experienced sexual abuse to be able to apply. Related non-sexual abuse is also part of the framework that's used to assess the application, but non-sexual abuse alone it doesn't make someone eligible to apply to the National Redress Scheme. There are a couple of exclusions, so if a person has previously received a court-ordered payment, they're not able to apply to the National Redress Scheme, and that includes class actions as well. And people in jail can't generally apply to the redress scheme. There's a special circumstances process that they can go through to be assessed. And the other hurdle is that people with what the scheme calls serious criminal convictions, so people who have been sentenced to a term of imprisonment for 5 or more years for one offence, are not automatically entitled to redress and need to go through an additional assessment process to sort of get over that first hurdle. The main thing I wanted to talk about is institutional responsibility. So, as I say, the scheme relates to institutional abuse. The federal government administers the scheme, the Commonwealth government, and the different institutions, which is states, churches, the sports club around the corner, all of those different things, they have to join the scheme and say that they will foot the bill for applications that are related to that institution. So all of the states have joined, and the big churches have, the Catholics and the Anglicans. Most of the Catholics, there's some orders that aren't in yet, and other non-governmental organisations have joined. And if institutions haven't joined, they have until the 30th of June next year to join. There is no power for the federal government to compel them to join. So what that means is that institutions really need to opt in to be part of the redress scheme. As Di said, there is a list on the website of institutions that will have and also haven't joined. Some of them say that they're intending to join and others don't. The process of joining means that the institutions will be assessed to see whether they can meet any liability that they'd have under the scheme. So that's why some smaller institutions may just not be able to join in terms of funding. The definition of institution is really, really broad. So it's basically anything that isn't a family or a person by themselves. It obviously involves companies and schools, and boys' homes is probably a fairly common example. Often people who were in boys' homes were in a number of institutions. The application, as Di said, you can only make one application, and that $150,000 limit that I spoke of before applies to the whole of the application. So it doesn't matter if you were in one institution or in 20. That's the maximum amount that you're able to receive. The I suppose tricky point if you were in a number of institutions is that all of those institutions need to have joined the redress scheme for your application to be processed. If they don't join, your application will be waiting until the 30th of June next year to see if they do join, and then I don't know what will happen because it hasn't been announced what will happen yet, so we'll see. Now, the redress payment is worked out in a very strict sort of way, and it's broken into categories of the type of abuse that people experienced. You can see behind me, the 3 levels are called exposure, contact, and penetrative abuse, and the framework is sort of, you add them up, it's cumulative as you go across the columns. So the first 2 components are fairly self-explanatory. They are amounts for the recognition of sexual abuse and for the impact of that sexual abuse. The next one is related non-sexual abuse. So related is, I'm not sure how related it has to be related, but that would be physical abuse and neglect, which is often common in the sorts of institutions that come across my desk. Institutional vulnerability is the next thing, and that really relates to, it's about where people's living arrangements meant that they were more at risk of experiencing sexual abuse. So residential institutions, I think, are a relatively good example because if you live there, you're more at risk. And finally, extreme circumstances of sexual abuse is only available for applications that involve penetrative abuse. It's defined very, it's not super clear what it means. In the legislation, it says if it was particularly long-term, egregious or disabling, then it could be extreme circumstances. There's also some policy guidelines which are protected information under the scheme, so they're not released to the public or to our service. The sort of bottom level there, exposure abuse, obviously involves no physical contact, and one of the exclusions under the scheme is that if the abuse involved 2 children, so the perpetrator of the abuse was another child, and it didn't involve any physical contact or penetration, which would put it in that exposure level, it's not abuse within the scope of the scheme. So to say that a bit more clearly, exposure abuse between children, you can't apply. You can't make an application about that. These amounts, if you add the top one up, you get $150,000. That amount that you're assessed at will also take into account any prior payments that you might have received on behalf of the institution. In other states, there were some governmental redress schemes. In Victoria, there's been plenty of civil litigation claims. They're indexed for inflation. So if you got $20,000 10 years ago, it'd be worth a bit more now. And that sort of indexed up amount is taken off whatever you're assessed at under the redress scheme. The money stuff is a little bit dry, I'm sorry about that, but it's worth covering so that everyone knows what the scheme's doing. As I was saying about the institutions having to join, there's also a provision for state governments and I believe the Commonwealth Government to become the funder of last resort for defunct institutions. So that's institutions that no longer exist. That's only recently the first declaration has been made for 4 institutions in Queensland, and 3 of them are Aboriginal residential care institutions, and I don't know about the 4th off the top of my head. What that means is that the Queensland Government will foot the bill for those institutions. I think it's important to note it's a bit different to sort of like a catch-all funder of last resort. So if there's a local footy club or a small community-based disability organisation that doesn't have the funding or doesn't have the money to join the redress scheme, at this stage if they don't join, you can't make an application in relation to them. There's no provision for one of the state governments to sort of pick that up. The next thing is just about nominees. So obviously it's quite difficult to deal with the scheme directly for some survivors, and I mean most people don't like dealing with bureaucracy anyway. So the scheme allows for applicants to appoint a nominee. There's two types. So an assistance nominee is just a touch point for the applicant to be able to have that person liaise with the scheme on their behalf, and basically they can do anything that an applicant can do except apply, accept or reject an offer. So they don't have the same sorts of decision powers as the actual applicant, but they can sort of deal with the scheme on their behalf, and often knowmore acts as the nominee for our clients. The other nominee is a legal nominee, and that's a substituted decision maker. If a person has a power of attorney or some other substituted decision maker arrangement in place, then that person will need to be, or that if it's like the state trustee will need to be the legal nominee, because they'll need to make the decisions in relation to the scheme on the applicant's behalf. The last sort of thing I really wanted to cover was the Redress Support Services, which Di has helpfully covered, and there's a bunch of money that's been given to different organisations for them to be able to provide support to people who are going through the redress process. And in more sort of metro areas, there's often face-to-face services. As you get further out, there's less services, as we all know, and Blue Knot has done a really good job of, they're really sort of doing a lot of the rural and remote work. The Redress Support Services can help people actually apply, and as Di said, the form is, I should have brought a copy to wave around, but I think it's, 35 pages? Yeah. It's a big form, and it's very difficult to do for the first time, I think. So the support services can help people to apply, and they also offer counselling throughout that process as well. They're listed on the National Redress Scheme website, same as Di. I'm not going to go through them all because we'd be here all day. But it means that there's more access to the scheme in different sorts of areas, and knowmore as well can help people understand their legal options with the scheme and outside the scheme as well. I think that's everything. Oh yes, the other thing that I didn't put a slide in about was that, can you pass me the little guide at the bottom? So, thank you. As I said, we've recently had financial counsellors come on board. One of the main things that they help people to understand and work around is that the redress payment, it's not counted as income, but it is counted as an asset for the purposes of settling payments. Our financial counselling team have put together this guide called Helping Clients Receiving a National Redress Scheme Payment. This is the only copy, the hard copy, so you can't have it, but we do have it on our website, and it is more up to date, and it's written quite plainly. It's fairly easy to understand, but it helps people to, if you're working with someone who is going to be in receipt of a redress scheme payment, it helps you to sort of understand what the implications of that are. Debts and things aren't to be taken for, if say you had a garnishee order, they shouldn't be taken off the redress payment, but like I said, for settling purposes, it's counted as an asset, so that's just something that people need to be aware of as well. I don't think I have any more slides, except that's where we are. We're right down near Spencer Street Station. You can visit our website, and that's got all our information on there as well. And there's also the National Redress Scheme's website there as well. We have a toll-free number. We're really happy to talk to anyone who has questions and give some legal advice to people. Great. All right. I might sit down with Di, and then if there's any questions, we can go through them.
Hello. I was just wondering if you knew how they made the decision that people in jail couldn't apply?
I don't know the rationale behind it, but I have had it explained to me that it is very... In jails, there aren't the same sorts of services as we have in the community. This is a difficult process for any survivor, and I don't think you'd have the same support in jail as you would on the outside. The idea is that people will wait until they finish their sentence to apply. One of the sort of special circumstances things is if someone's going to be in jail past the scheme's sunset day, which is the 30th of June 2028, then they can sort of go through that exceptional circumstances process to be made able to apply. So they don't, in theory, wouldn't miss out if that was successful.
Thank you.
Absolutely. Any more questions?
Any other questions? Oh, good.
Hi, I'm just wondering, when you talked about the assistance nominees, I'm just wondering, can advocates be assistant nominees?
Yeah, so anyone can be an assistance nominee. As I said, I often will be the nominee for my clients, but anyone can be. So it could be a partner, it can be an advocate, it can be the lady down the road.
Thank you.
Di just mentioned something as well that is probably worth mentioning, is that the, as Di said earlier, the scheme has taken a fair bit of time to process the applications. They recently, I think since maybe a month ago, we weren't sure, but they went from having 5 independent decision makers to I think 18 relatively recently. That said, the scheme will sort of be able to prioritise applications for people who are ill, and the idea is that people would get to receive an outcome before they die. If an application is made, if I made an application and then I died before it was decided, the application would still be decided and then the money would go to my estate. So the estate, you don't miss out, but you're not there to, I suppose, receive the payment, if that makes sense.
Hi. You mentioned that the application form is like 35 pages long. What's the scope of information on the application that makes it so lengthy?
Yeah, so the form's in 3 parts, and the first part is personal details, so that's fine. You can do that in 10 minutes. The second part is the details of the abuse that you experienced, and it is not sufficient to say I was sexually abused by Joe Bloggs. It has to be, because of those categories, the exposure, contact, penetration, it needs to be clear what happened. So a fair bit of detail is required. The third part is the impact that the sexual abuse has had across your life, and that's a bit easier. There's a free form box if you want to write a statement, or there's some check boxes if you want to just tick them. The bulk of the application is that sort of second part. Where it gets a little bit tricky is if, as I said, you can be in multiple institutions, and often people were, there needs to be a separate part too, so the details part, for each institution that you were in. So sometimes I have one application on my desk right now that's like this thick, because you just have like 6 different parts of the same thing for each institution.
So the other question I had myself, maybe you can answer, is about foster care and
Oh yes.
children who may be placed in foster care by the government.
Yes. We talked about that on the phone, didn't we? I said I'd mention it and then I didn't. So foster care is an institution. As I said, it's defined really broadly. It can be tricky though, because as I say, the institutions need to have joined. If it's foster care run by the state of Victoria, for example, the Victorian government has joined, so that's fine. You're easy. If it's foster care run by like a Catholic ministry or a local organisation, that's a different circumstance, and unless the institution that's responsible for that has joined, your application can't be processed. I suppose that's the real difficulty with saying foster care is always in, but but like state wardship is a relevant institution for the purposes of the redress scheme. Yeah.
It's oh, sorry. I was just going to say something. So, children in English to this. Sometimes paperwork doesn't
Could you tell me what would happen if a client of in an institution had already been to court and the perpetrator was found not guilty on the basis that the client was non-verbal? Is the client still able to apply for compensation?
Yeah,
redress?
so there's two things there. First is, well, there's a couple of things, hold on. The first thing is a finding of not guilty in a criminal proceeding doesn't mean that your civil rights are abrogated, so you could still sue the perpetrator or the institution, and it doesn't mean that you can't apply for redress. So you can still apply for redress. And the second point is that, as everyone will probably know, the criminal standard of proof is beyond reasonable doubt. So no reasonable person would doubt that Joe Bloggs is guilty of the offences charged. The civil standard is the balance of probability, so more likely than not. And then the redress scheme uses a lower standard than that even. They talk about whether or not the applicant is reasonably likely to be entitled to redress. So it's a much lower bar to jump over, and while the application needs to be filled out, so that might be difficult with someone who has, if someone's non-verbal, it's obviously going to be more difficult than with a client that doesn't have a disability, but they're not precluded from applying at all. Yeah, even if the person was found not guilty, the criminal proceedings don't have any effect on the redress application, and without opening the Act up to double check, I'm fairly certain the information can't be shared from the redress scheme to the criminal courts either.
Yes.
The information is all really heavily protected. Yeah.
Any more questions? No? Okay, thank you very much, Di and AidAn. It was very, very useful and very helpful. Thank you.
Thanks,
So
everyone.
I think we will go to a break, and if you could return to your seats at 2:30. Thank you.